The Supreme Court has struck out a suit filed by President Muhammadu Buhari and the Attorney General of the Federation, challenging the constitutionality of Section 84(12) of the Electoral Act. A panel of 7 justices, led by Musa Datijo Mohammed, JSC, unanimously struck out the suit, describing it as an abuse of court process. The section provides that, and I quote, "No political appointee at any level shall be a voting delegate or be voted for at the convention or congress of any political party for the purpose of the nomination of candidates for any election," unquote. The court held that Buhari, having earlier assented to Section 84(12) of the Electoral Act 2022, cannot turn around to approach the court to strike it down. It also said that the request by President Buhari to the National Assembly to delete the provision amounted to constitutional violation. Justice Agim described the suit as a ploy by Buhari to get the court to validate the violation. The Chief Justice of Nigeria, Tanko Muhammad, has also responded to a protest letter sent to him by 14 justices of the Supreme Court, complaining of poor welfare conditions and the deplorable state of the court. Reports say that a leaked memo by the 14 justices of Nigeria's top court, chronicling the operational challenges that have almost crippled the efficient adjudication of cases at the court, was the first of its kind in the 58-year history of the court. Justice Mohammed responded to the leaked memo in a statement issued on Tuesday by his spokesperson, Awuraka Issa. The issues he addressed include non-provision of diesel allowances for justices, non-provision of equipped offices, accommodation, and the complete set of vehicles for new justices appointed 2 years ago, among others. In a related development, a Lagos-based human rights lawyer, Malcolm Omirhobo, on Thursday set social media abuzz after he appeared before the Supreme Court dressed as a semi-lawyer and a traditionalist. The lawyer, who is from Delta State, claimed to have been expressing his fundamental human rights following the recent ruling of the Apex Court, which legalized the wearing of hijab in schools in Lagos State. He later spoke to journalists. Here it is.
By the Supreme Court judgment, I've been given license to dress in our religious attire because it should be an infringement or a violation, a flagrant violation of my fundamental rights to freedom of thought, conscience, and religion for anybody to stop. You saw I went into the Supreme Court, and you see, we've been given the license. Even my children would dress like this to the school, and I will encourage my fellow traditionalists, those who are serving Oloku and Shango and Shopono, God of thunder, God of iron. I will encourage them to dress like this because it's always good to be religious. We need to be close to the spirits. You can see I'm not wearing any shoes. This is the, in fact, if I has told me that if I wear shoes, I'll be dead. So what will I do? I have to obey the spirits. You see this eye? If without it, I can't see the evil spirits coming to attack me. So with this, I can see them. So you see, we've been given license to, by the Supreme Court judgment of Friday, we've been given the license to dress in our religious outfits because it's the mood. It's the mood of our worship. Nobody can do it. Nobody. Even the president can. Buhari can't arrest me. In my own fundamental rights, nobody can. It's my fundamental rights. So this is my outfit. I can stand anywhere. This is my outfit. What is alien? There's no law, Section 45 of the Constitution that derogates the right to freedom of, the rights in Chapter 4 generally, which includes the right to freedom of religion. It's not clear on, he said there should be a law that can derogate this my right. And there's no law in Nigeria. There's no even law in the Legal Practitioner Act that derogates or tells me how I'm going to dress.
We're now being joined by the man himself, lawyer and human rights activist, Malcolm Omirhobo. Mr. Omirhobo, welcome to the program.
Thank you for having me.
Well, I have a number of legal issues that I will like to ask you to help us unpack. But let's start with this, your dressing. I mean, this is not regulation dressing for lawyers. And then you went to the Supreme Court. Was that sarcasm, or was that, you know, a comedic effort? In terms of your reaction to the ruling of their lordships in the matter of the wearing of hijab in schools, what exactly were you trying to draw the attention of the Judex to?
Well, I would have asked you, what religion do you belong to? Sorry. Are you a Christian or Muslim?
No. I'm the interviewer here.
No, I'm
a Christian.
You should have complied now.
I'm a Christian.
You should have dressed in your, because that's what the judgment said, that we can now dress, we can now express our freedom freedom of religion by dressing in our worship mood as prescribed by our religion. So I would have expected, if you're a Selena, you'd have worn your that cap or something. If you're a Catholic, you'd have put a big cross and all that. And look at me, we're all in compliance. So I went to the Supreme Court basically to make a statement. Like you said, frankly, it's a sarcasm on that judgment that it's going to lead to it's going to lead to chaos, disunity, distrust, and it's going to divide us. You know, religion is a private right that is supposed to be kept privately in your house, your private school, your religious school. When you come to the public, you put it aside. And that is why the Supreme Court, like I rightly said earlier on, erred by refusing to read the Constitution as a complete document. Section 10 derogates Section 38. Section 38 is a private right, while Section 10 is a public right, or I would like to say interest, that says there should be no state religion. What is that? It said no state or the federal government should adopt any religion as a state religion. What is the word adopt? If you look at the word adopt generally, you discover that adopt means taking as your own, encouraging, or using something as. So when you look at the decision that says that certain students, female students, should dress in their religious outfit in a public school, look at the word public school, not even a private school, not a Quranic school, public school, then there's a violation of Section 10. I'm sure the Supreme Court did not take this into cognizance and say, look, your right to freedom of religion is not absolute. It's not absolute. None of those rights many of them are not absolute. All the rights are being derogated one way or the other. Section 10 dilutes or mutilates your right to religion. When it comes to public, you keep that your religion aside. You imagine if a class teacher comes into the class and he puts his head up and he says, that girl is wearing a hijab, she's a Muslim. That guy is putting a leke, he's a traditional. That guy is wearing a Rasta, he's a Rastafarian. That is a Buddhist. So immediately the teacher knows the students not by name, by religion. So if he's biased to the Muslims, so that person must be a terrorist. If he's biased to Christians, say, oh, that person is a lousy person, he's always speaking in tongues. It's not right. Those days, nobody knew what is the craze about hijab right now. Those days, you don't know who was who in school. Everybody, you just see everybody dressed in a uniform, and the teacher comes, he doesn't know who is who until he asks, what is your name? And probably through your name, so the decision, it's wrong. The judiciary has to be reversed.
Okay, well, when you decided to go to court in this attire, were you not bothered that the court, their lordships could have, charged you for contempt in the face of the court? They went on recess, they came back, and you were there. And then they went on recess again. They could have charged you for contempt because, you probably scared them. Even today, when you came into the studio like this, people have asked me, they say, Doctor, I hope you're all right. Are you scared? And I said, don't worry.
No.
I'm not scared.
The watch parts of Oloko, we are not dangerous people. We are good people.
Okay, if you may also explain this attire.
Well, let me start by saying that the justices of the Supreme Court, they cannot cite me for contempt. If they do, they would have erred. Because there's no law backing them. I didn't disturb the court proceedings.
With this attire?
I sat down as a Nigerian in compliance, in exercising my right to access to court. Any Nigerian has right to go to court. And for crying out loud, I'm a lawyer. So I sat down. The first and second row was already occupied. So I sat down in the third row, and I was very visible. Now, the justices saw me, and I commend them. They behaved very maturely and with high level of discernment. They didn't say anything, but I knew they read my mind. They read the handwriting on the wall, and they couldn't do anything because they know the law.
But couldn't you have adopted another method? I mean, only this apex court can reverse itself. What you could have asked for a judicial review of that particular.
You can't.
Why not?
The Supreme Court is the end of the road.
Yes,
you only go after Supreme Court is heaven.
Infallible.
No, you cannot. Nobody has powers to reverse the decision.
No,
the only way out. No, you
can
can't
ask for a review.
What are you going to review? A Supreme Court judgment? It's not possible. What will happen, and what I suggest is this: one, with subsequent cases coming up before the judiciary can decide not to follow that line. You can remember the issue of local standing, how it used to be before. Everybody, once you come, they throw your case out based on Abraham, Adesanya, and co. Adesanya's case. But when Gani now opened the doors, you now see the court start moving away from. If you cite Abraham Adesanya and nobody listens, the court will say no. That's an old law. We follow the Gani way that an individual now, if you have enough interest, you can now have local standing. So gradually, the court will now start erasing or deliberately in a judgment decide not to follow its old. Another way out is the various state House of Assemblies and the National Assembly can pass a law immediately and say, look, let's take religion out of our public life. No more religious dressing in public school. No more. So there's a law already, which the judges must interpret, and it takes away that decision.
Okay, very interesting week. All kinds of details coming from the Supreme Court. The Supreme Court, in a ruling a few days ago, struck out the suit filed by the President and Abubakar Malami, the Attorney General of the Federation, with regard to Section 8412, which was a product of legislation. That's the Electoral Act 2022. And their lordships were saying in their ruling that, look, the president, having assented to that original legislation, cannot now come through the route of the court to say that the Supreme Court should invalidate Section 8412. What are your thoughts on that ruling?
The Supreme Court has done marvelously well on that because the president cannot appropriate and reprobate. He has assented to it. Why? It's an afterthought. And this is the characteristics of this government. They are not setting, they abuse the rule of law. And I'm happy that I can see checks and balance in this issue. You know, the judiciary will say, no, you can't do this. And I wish they could do more of this. Stand out and, face the executive instead of always compromising when they come to them. I thumbs up for the Supreme Court on that.
Well, I saw a letter you wrote to the National Judicial Council in which you were invoking freedom of information rights and privileges with regard to the funding of the Supreme Court and the management of the funds. And all of this will seem to be in the context of the protest by 14 justices of the Supreme Court that they don't have access to internet. They don't know how money for training is being spent. They don't have the full complement of vehicles that they are supposed to have. You'll find, these justices practically saying, we have been shortchanged. Nobody is explaining to us how money meant for the Supreme Court is being spent. Okay, what is your interest in the matter? And do you think that the NJC would oblige you with a response? Given the fact that the CJN himself has already put a letter out there saying, look, don't mind them. They don't know what they are talking about. They are all riding SUVs.
Mm-hmm. Well, the law is what it is. The law is the law. Nobody is above the law. The CJ, Chief Justice of the Federation, is not above the law. NJC is not above the law. I wrote, I wrote 2 letters, not 1. I wrote 1 to the NJC because after the estimates of the judiciary has been sent to the executive, that's the president now sends it for approval. After appropriation from the consolidated funds, the money is disbursed not to the court. It is disbursed straight to, by virtue of Section 82 or thereabout of the Constitution, it's disbursed straight to the NJC. NJC now disbursed the money to the heads of all the courts. Now, I have asked NJC to tell us how much they received and how much they disbursed. That stops there. Then I also wrote a letter to the Chief Justice of the Federation asking him to render account, to give us vouchers, receipts, bank statements, how the monies that he has received from NJC has been expended, so we can compare notes and see whether there is indeed misappropriation or embezzlement of funds meant for the administration of the Supreme Court. You know, so that's what those letters. And immediately after 7 days, we'll be going to court. It doesn't matter. Let it be on record that a Chief Justice cannot respond to an order of court. I want it tested, because, and you know, it's quite unfair. What did Onoge do? Because he didn't fill the form. You see? Did you hear any allegation like this when Onoge was there? It's unimaginable. And I warned Nigeria about Honorable Justice Tanko on record that he's not a fit and proper person to be a CJ. And I've been vindicated. So I'm waiting for his response. And if I don't get a response from him and the NJC, I will go on. We're going to follow the matter to its logical conclusion.
Okay, but you know there is a code, you know, among the Judex. As an officer in the Temple of Justice, you are taking on the apex court. You are taking on the Chief Justice of Nigeria. You don't have any reservations about how this could affect you when you show up next in court and you have a matter and knowing that, you know, judges, you know, they are like brothers. They will say, oh, this troublemaker has shown up again. You are not worried about that?
I'm not worried. Let me tell you something. You see, each time that Nnamdi Kanu's case trials comes up, you see that DSS come to court, the police, they chase away lawyers and journalists. Do you know how it stopped? Do you know how it stopped?
No.
I stopped it. I sued the Chief Justice of Federal High Court, Honorable Justice So. The matter is still on now. He has not filed his defense. I sued him for dereliction of duties and his registrar and the DSS. Immediately I sued him. The next week, he made this arrangement. So I don't, in the local parlance, I don't send. I'm not asking. I told Justice Lima once in Federal Court, I say, once you see me in your court, if you know I deserve the case, give me my judgment. If you don't, I don't mind. Posterity will judge me and you. But mind you, any public interest case I file, for making an attempt to file it at all, as long as I appear and file it, I have won the case. So I am not bothered. I am not chasing SAN. So I don't have anything. I'm not afraid of anybody. I'm not looking for favors. So I don't mind. I will appear before them. Let them do their jobs. If you think I deserve the judgment, give me. If you think I don't deserve it, so be it. So I'm not bothered. Nobody is above the law. Not the CJ, not even the president. The only thing that helps the president is the immunity, but he's a Nigerian. So nobody, until we start thinking in this direction, we will start letting a lot of things, we'll start allowing a lot of things go out through the windows. And we must stop this attitude.
Well, another major legal issue that came up this week has to do with former Deputy Senate President, Ike Kuremadu, who, along with his wife, was charged to court, Osbridge Magistrate Court in London, for conspiring to bring someone to the UK for organ harvesting, it is called. And that case has turned almost every Nigerian into a lawyer, including people, you know, who have no business with the law, all kinds of experts, particularly on the social media. What do you think, you know, as a lawyer, what do you think the issues are, both from the British end and also the Nigerian end, in the light of some of the revelations that we have had in the last 48 hours?
Well, the facts are not, they're sketchy, or, I mean, they're not clear so far, but what I see here is, in some accounts, they say the boy is 15 years. In another account, they say he's 22 years and all that.
21.
21.
Yeah.
But I think the one, if it's established that the boy is 15 years, then he's not, he doesn't have the capacity to consent to such a contract. It's his parents or guardian that are supposed to consent to it. But and again, if he's 21, there's no problem. But basically, was there any contract? Was there any written contract? And there's none. They have not produced any. So I wouldn't want to judge the Koremadus. Let us watch at it unfold. When all the facts are tabled on the table, when all the facts are on the table, then the British government knows what best to do. So right now, we might just be speculating or conjecturing what is or what is not. But it's a very sad situation for many people out there who are not who are impecunious, who are not financially capable, and they have to sell all, because I don't think I want to give my kidney to anybody. But financial situations make people to want to. I'm not sure it's out of love. It's out of, look, let's pay you some money, or like the British government is trying to establish that there's some kind of deceit. We don't know. I think he's lucky it's England. If it was India, nobody would ask any question, and by now the operation would have been done.
Okay, so, another legal issue that is of international dimension, Roe versus Wade, 1973, has now been overturned by the Supreme Court of the United States. I'm sure you've been following the controversy. So what does it really mean in terms of the rights of women to choose, or families to choose, and women reproductive rights?
Well, I think that judgment, it's a Supreme Court judgment.
Yes.
Again, so it stands and must be complied with. And law is dynamic. Law is like social engineering. Mm-hmm. As they go in the decision of the court to abolish abortion and all that, as they go along, if it's no longer favorable, they will upturn it. But it's really going to affect the social life of the Americans. But with time, they will adjust to it, and they will adjust to it. It favors some people, and some people there's for and against. Some people are happy, then the other people are not happy. So, but as they go along, but they must comply with it, whether you like it or not. They must comply with it. So with time, if there's need to reverse or pass a law to support or delete such situations, the American Supreme Court they know what to do about.
Yeah, or Parliament perhaps, to come up with legislation to override the Supreme Court, because the matter does not stop with the Supreme Court. Okay, finally, I wanted to ask you, this whole political process about the qualification of candidates. Now, in the last day or so, there's been this controversy about the qualifications of the presidential candidate of the All Progressives Congress, Asiwaju Bola Ahmed Tinubu, who in his form that he submitted to INEC indicated that he has a degree, but he doesn't have primary school, he doesn't have secondary school, because his documents were stolen when he was in exile. And Nigerians are saying, no, this same man, when he was governor of Lagos State, filled a form and claimed that he attended Aroloya Primary School, he attended government college Ibadan.
Yeah.
So why is it that these earlier references have disappeared, and it's now saying he just got a degree because he cannot provide documents for primary school and secondary school? And some NGOs, civil society groups, have been saying he's liable for perjury. Can perjury apply in this case? Can it have retrospective effect? Has it violated anything under Section 131, dealing with the qualification for the presidency, and Section 138, which interprets the meaning of that qualification?
Well, first and foremost, I want to say that I don't really have confidence in this election process or the forthcoming election. Like I've always canvassed that we need to renegotiate the unity of this country through a referendum. But suffice it to say, the majority are carried along, so we are in it. The issue of the primary and secondary school certificate of the APC flag bearer is to me is strange, and with the contradiction, I think what the NGOs and everybody concerned need to do is they have to get those forms first, put it on the table. His statement now, put it on the table, and with that, there's no way they will have a case of either perjury or a violation of the section you just cited. And by so doing, they can go to court or they can petition. But if they're able to study these forms, if there's any at all, they're able to study it and put everything together, there might still be a leeway for the flag bearer. It depends.
Yeah, because the law says you don't even need to pass school cert. You don't need a degree.
Yes, he can fly.
To be president of Nigeria.
Yes, he can. Because
in fact, if INEC says you are good enough, you are good enough.
Yes.
So do you think going forward, we need to have a review of the relevant sections of the Constitution dealing with qualifications for political office? That there will be certainty.
No, one thing I come to realize with our educational system is that some people are graduates, PhD holder, but they are illiterates. So to me,
don't look at me. No, I'm not that illiterate.
So, but I would say,
I'm just joking.
I would say that education is not just having certificates; it's exposure. There are people who have not been to the university, and I know they are better than those who have been to the university. So I think it's still okay, but I think secondary school is okay. If they just have school cert, it's okay. Basically, because somebody can finish secondary school, train himself with this day of internet, exposure, reading and all that, might become a great person without going to school. That is the truth. So I don't think it's educational qualification that will give us a good president. I'm not talking about Buhari or Tinubu. I'm saying generally. There might just be this young man from Akoko Edo or Zamfara who came to Lagos, read on his own and get exposed, worked here and there and being a successful businessman. He could be a great president without going to seeing the forwards of the university. That's my take. But a school cert basic is okay. Not necessary degree or you must have PhD, because by so doing you might be edging out the best materials.
Okay, let's go back before we round up now to where we started from. Okay. For how long do you intend to continue with this campaign in this herbalist DBR attire? Olokun. For how long will you be going to court like this?
Forever and ever. See, I've been waiting for this opportunity. Now that the Supreme Court said, dress in your traditional regalia or outfit, I am so happy. I have matters tomorrow, 4 matters.
And you will go like this?
Wallahi, I hope you'll be there. I will be live at the Federal High Court. No, I'm not kidding. I will be there. I will sit down. There's this senior advocate, Jibri, was castigating me and saying, why didn't I speak? That I would have dared the judges like Daniel dared Buchanan and all that. So I told him, don't worry, action speaks louder No, you should wait. And that's what's going to happen. I'm going to sit.
And if you appear in court and your case is not, your file is just pushed to the back.
They're fantastic.
So you just keep you keep going there, and your clients will start wondering, this man, the court no longer listens to him.
So will it be fair for the judge to disobey the judgment of the Supreme Court? It's not right. The Supreme Court has said anybody that wears, that is the import of the judgment. You wear your religious regalia in the mood of worship, and if you go to anywhere and they stop you, that will be a violation of your right. So if any judge decides to stop me, to hear me, he has violated my right. I will carry out. I have trials. I have like 6. I will have under 2 matters. Two in Federal Court on Monday. I have one in Lagos Island. I have a trial in Ikeja. I will go and conduct my trials like this. Because you know now, even in law, lawyers now wear hijab inside the bar, which is not normal. You remember the case, Massa's case, that was refused call to bar in 2000.
Yes,
in 2018,
yes,
they called her. So she's wearing hijab. Everybody's wearing hijab. Even some people wear this small Hausa cap and put a wig on top. So why can't a local worshipper do his own?
Or a masquerade, and your masquerade.
You will come.
A lawyer will appear in court like your masquerade.
Yes, even this Isha flipping juju and all that, they will come. And then that is it.
Anyway, I would like to thank you very much.
I'm grateful.
Mr. Malcolm Omirhobo,
I appreciate
for joining us on Days Live today.
I'm most grateful. Thank you so much.
Thank you very much indeed.
Thank you.